Morning, everyone. Jeff Koppel, Realtor, General Contractor. Sorry you haven't seen me in a while. I've been busy helping my clients buy and sell houses. So it's that time of year. Summertime in Texas seems to be pretty hot market for real estate usually. Well, today, what I thought I would talk about, I had a transaction come up recently that my buyer that I was representing had hard dates that they had to close on this acquisition of their new house by. And timing was pretty tight on the whole deal, and we actually ran into a situation where for a time it looked like we weren't going to be able to close by the date that they needed to close by. So because of requirements that were in place due to legislation that we've had since about 2013. So anyway, I thought I would first of all explain the situation that we were in and how we came to that scenario. I thought what I'd do is kind of just do a brief explanation of what our situation was in terms of the legal requirements. So back in about 2008, I don't know if some of the younger people watching might not even remember this, but we had the foreclosure problem with mortgages that have been created in the couple of years prior. So as a result to that, some of the mortgage defaults that we had, as a result of that, a couple senators, Dodd and Frank, basically proposed an act, the Dodd-Frank Act, which was consumer protection laws that were adopted. And as part of that legislation, the Consumer Financial Protection Bureau was formed, which would oversee all the new legislation that was put in place. The legislation that was put in place, it was Regulation Z, or a lot of people refer to it as Reg Z legislation. And what that did in particular for mortgages is it now required that if you apply for a mortgage loan, the lender had to send out basically a loan estimate to you within 3 days of applying for the loan. And then another piece of another requirement that was put in place was basically your closing disclosure had to be sent out from your lender to the borrower 3 days prior to closing of the loan, so that the consumer had an opportunity to review it before going to the closing table. Before that, I mean, we basically just had the HUD-1 and the truth in lending statement that were presented to you at loan closing. So, the Dodd-Frank legislation made the decision that consumers need a little bit more time to review that, so that they could determine exactly what all the loan terms were and all that. So, okay, so the situation that we ran into, my buyer had some hard dates that they had to be in their new home by, due to some financial issues that they had. And they also were scheduled to close on the loan contractually. So on the purchase contract, they were required to close on this particular loan to purchase the property by a given date. So what happened is the lender sent out the loan estimate when they were supposed to, and they also sent out the closing disclosure form when they were supposed to. The problem is with the closing form, when it was sent out via email. And unfortunately, that email went to the borrower's spam bucket. So they didn't see it. They didn't see it for a whole day. And then the lender reached out to them to say, hey, did you receive this? And by that time, we were within the 3-day waiting period. So that meant that the loan would either have to be moved out to another day, which if that happened, then they would basically be in default on the contract. And then we would be at the mercy of the seller to decide, okay, do you want to grant us the extension on closing? And not to mention the other, possession requirement that they were trying to get to comply with basically a court order would have been not met also. So they basically had two financial emergencies going on there simultaneously. So, okay, so I always thought that the 3-day waiting period was a hard and fast. There's no flexibility on that. But because of the team that I work with, in this case, a portfolio lender And I'll go into the difference of that after we talk about the particular regulation that we made use of. Because they were really familiar with the Reg Z requirements, we were able to find the 3-day waiting period waiver. So I thought I'd go ahead and share my screen with you and just share the text of that waiver process. So, okay, here is the part of the Reg Z subsection 1026.31, subsection C, subsection 1, subsection 3. And basically, this gives you the ability to apply for a waiver of the 3-day waiting period. So I thought I would just kind of read through this a little bit to, kind of show you exactly the wording, and then I'll translate it in English after I'm done reading it. So anyway, here we go. The consumer's waiver of waiting period before consummation or account opening. The consumer may, after receiving the disclosures required by paragraph C1, now that's in our case, that is the closing disclosure. They may modify or waive the 3-day waiting period between delivery of these disclosures and consummation or account opening if the consumer determines that the extension of credit is needed to meet a bona fide personal financial emergency. And again, I said that there was the personal financial emergency in this case was they were going to miss the closing date, which would mean that they're out of contract. And also they would miss the possession requirement for the court-ordered action that was going on with them. So now I thought I'd go down here and just kind of look at the official interpretation of that wording that I just read up here. Under here, modification or waiver. A consumer may modify or waive the right to the 3-day waiting period only after receiving the disclosures required by 1026.32. And again, that's the closing disclosure from the lender. And only if the circumstances meet the criteria for establishing bona fide personal financial emergency under 1026.23. Whether these criteria are met is determined by the facts surrounding individual situations. The imminent sale of a consumer's home at a foreclosure during the 3-day period is one example of a bona fide personal financial emergency. Each consumer entitled to the 3-day waiting period must sign the handwritten statement for the waiver to be effective. Okay, so what does this mean? Basically, the number one, the lender has to have sent the notice of, the closing disclosure, sorry, before the 3-day waiting period. So in other words, say they normally send it out like 4 days before closing. So to comply with the 3-day, okay? And then number two, the consumer has to have a handwritten request, not a form letter, but a handwritten request. And then all people that are going to be on the loan have to sign it. So in this case, it was a married couple. So husband and wife both signed it. And then number three, the more cases of personal financial hardship you can demonstrate in the letter, the better. So in this case, they had two. They had, if they missed the closing date, there was a non-movable, basically state inspection requirement that was already scheduled by the state. They had no flexibility in changing that scheduled date. And number two, they were going to be out of contract on the purchase contract, which would mean that they would have to, possibility that they would lose out on purchasing the property altogether if the seller decided they didn't want to extend the extension. So in our case, we were able to get the waiver approved by the underwriter. It's approved by the lender's underwriter, and we went ahead and closed when we needed to. So now one thing I wanted to mention too on our particular deal, use of this waiver, you may require a special kind of lender. In this case, my buyer was using a portfolio lender, and basically the portfolio lender hangs on to that loan for usually a period of at least 6 to 12 months to give it some payment seasoning before they go and resell it on the secondary market. Now, they have a little bit more flexibility on reselling of loans because they usually have payment history associated with it. So those loans are easier to market because they have some kind of a payment history. Now, I'm thinking that a loan broker may be a little bit hesitant to do this kind of waiver because a loan broker has to sell that loan immediately upon closing, basically. So I'm thinking a brand new loan with a waiver like this may not be as attractive on the secondary market. But again, we can talk to a lender to find out, in your particular situation, if they'd be comfortable doing that. So anyway, I hope this information has helped today and, let you know that if you are in financial straits and you need to buy or sell a property, and you don't have time to wait the 3-day waiting period, there is a possible solution to that. So, and again, since I've worked with that scenario in the past, I would be more than happy to help you with that. You can reach out to me at jeffkoppel@gmail.com. And again, as always, if you've got ideas for videos, I would be more than happy to put my answers out here via video format as time allows. And again, sorry I haven't been here for a while, but I look forward to working with you. And if you want to work with a realtor that has over 20 years of construction knowledge, over 15 years of real estate and personal real estate investment knowledge, and in addition to the real estate knowledge, I would love to talk with you. So anyway, I hope you enjoyed the content of this video today and look forward to seeing you on the next one.